Hi, Professor Lenz here, and today's lecture is on the Supreme Court. So on the Supreme Court, there are currently 9 justices. Now, the Constitution did not specify in Article 3 how many justices there would be. This is what we've sort of settled on over time. Now, to get on the Supreme Court, you have to be appointed by the President of the United States. And then once you're appointed, you're confirmed by the Senate by a simple majority vote. Now, very controversially, Supreme Court justices, once they are confirmed, are there for life, pending good behavior. There's never been a Supreme Court justice that's ever been impeached, that's ever been removed. And again, they're given life terms. So for example, there's been 2 justices in history who have served until they were over 90 years old. You heard that right. Now you're probably wondering, why would the framers of the Constitution give them terms of life? You know, for Congress, a lower house representative is only there for 2 years, and then they have to run for re-election. Senator, 6 years. A president, 4 years. So why are Supreme Court justices given life terms? Well, according to the framers of the Constitution, James Madison, Alexander Hamilton, and John Jay, who were the major figures, the reason was to insulate them from public opinion. They didn't want their judges to become biased in that they had to run for re-election and take positions that might be popular with certain constituencies. They wanted the judges to remain completely neutral as much as possible. Though I would point out, while that makes sense, certainly it might make good policy, especially in a country claiming to be a democracy like we are, to have our judges maybe up for election maybe every 20 years. That might be a good compromise. For the simple fact is, our judges may become too comfortable in their roles. And there is a concern. What happens if a judge becomes biased? You got to remember, these judges are appointed by presidents who share their political beliefs. So we already know that a Democratic president is going to put a liberal justice there, and a Republican president is going to put a conservative justice to the high court. So there may be actually already a problem of bias on the court. Now, justices of the Supreme Court only decide upon constitutional issues. They are not concerned about matters of guilt or innocence. So the only kinds of cases that make it to the Supreme Court are those cases where a constitutional question exists, such as a case having to do with free speech, or the Second Amendment with gun rights, or maybe there's a case having to do with illegal search and seizure, like the Fourth Amendment. The court receives about 10,000 petitions a year to decide on particular cases. And these petitions to the Supreme Court are called writs of certiorari. Writs of certiorari. And of those 10,000 petitions a year that the Supreme Court justices get, they only hear oral argument on 75 to 80 cases a year. So a very small percentage of cases actually get heard by the Supreme Court. Now, the factors that go into determining if the Supreme Court will agree to hear all oral argument, essentially deciding a case, are the following. Number 1, the likelihood of establishing a new precedent or legal framework. For example, the Supreme Court agreeing to hear Brown versus Board of Education in 1954 because it dealt with the question of racial segregation in public places. So, for example, in that case, the new legal precedent was that separate is inherently unequal. Number two, sometimes Supreme Court justices will agree to hear a case based on the fact that there is a current hot-button political issue that has no presently clear constitutional interpretation. For example, the legality of withholding federal funds for same-sex couples, or a case dealing with the legality of torture on foreign non-combatants caught in a war. Number three, Supreme Court justices will also consider taking cases if there is a persisting constitutional conflict between individual states and federal authorities. For example, there was a Supreme Court decision in the past that had to do with the power of the federal government to compel the individual states in America to establish a 21-year-old drinking law with the threat of withholding federal highway funding if the states did not comply. The Supreme Court was asked to decide on this case, and actually in that case they decided that yes, the federal government could use the threat of withholding highway funds to force individual states to adopt a drinking age of 21. So those are the three primary reasons why a high court, why the Supreme Court might agree to hear a case. Again, they are, number one, the likelihood of establishing a new precedent or legal framework. Number two, a current hot-button political issue that has no presently clear constitutional interpretation. And number three, persisting constitutional conflict between state and federal authorities. Now, the Supreme Court has ruled on a number of hot-button constitutional issues over the years, and they include the following topics: abortion, segregation in schools, interracial marriage, presidential immunity, that is, the president's claims that he is immune from prosecution for particular crimes while committed in office. The death penalty is another issue. The regulating of interstate commerce or trade between the individual states. Search and seizure. Discrimination in the workplace. Miranda rights, which basically means when you're arrested for a particular charge criminally, the police have to read you your rights, which includes the right to remain silent, which is crucial, right, of the Fifth Amendment. Supreme Court has decided on cases having to do with gun rights. So they've entered the fray into gun control, which is obviously a very controversial issue. The Supreme Court has decided issues on freedom of speech, which can be broken down into prayer in public schools, the right to use certain mind-altering substance as religious rites of passage, having to stand for the Pledge of Allegiance if it conflicts with your religious beliefs, media and press freedoms, as well as the right to protest. And by far, First Amendment cases make up the vast majority of those that the Supreme Court agrees to hear and decide on. Other issues that the courts have decided on that we might call hot-button issues: the question of affirmative action programs at universities, Native American territorial rights, gay marriage, which has gotten a lot of attention in the American media, the right to defense counsel in criminal trials, and even flag burning. These are all examples of cases that the Supreme Court has decided on through the years. Now, there are some general patterns of the Supreme Court rulings over their time. The Supreme Court, over the last couple centuries, has shown an overwhelming tendency to rule in favor of the federal government whenever it's in dispute with a state. Some examples for you all to look up include the following cases: Texas versus White, McCulloch versus Maryland, U.S. term limits versus Thornton, and South Dakota versus Dole. The Supreme Court can be said to have a mixed record on the notable First Amendment, the Second Amendment, the Fourth, Fifth, and Sixth. It has upheld the sanctity of these liberties in theory, but they've also placed restrictions or made exceptions in certain instances. Another general pattern in Supreme Court decisions has been that the court has been particularly friendly in its rulings toward the interests of corporate America. Some cases to look up that you might be interested in include Walmart Stores versus Duke, National Federation of Independent Businesses versus Sebulus, and Santa Clara versus Southern Pacific Railroad. Now, the current members of the Supreme Court, as I mentioned, there's 9 justices on the court. And I thought it would be interesting to just briefly go through who these 9 justices are to give you an idea of who appointed them, their educational backgrounds, and their experience. So the Chief Justice, which is considered the most powerful member of the Supreme Court, think of them as like the administrative head of the court, the one who organizes all of the opinions of the judges and calls forth the voting process. So the Chief Justice of the Supreme Court is this guy named John Roberts. John Roberts received his undergraduate degree from Harvard, and then his JD, his law school degree, from Harvard Law School. All of the Supreme Court justice members obviously all have law degrees, right? He served as a law clerk on the United States Court of Appeals from 1979 to 1980, which is the most powerful court in America below the Supreme Court, the U.S. Court of Appeals. He was special assistant to the Attorney General and associate counsel to Ronald Reagan in the 80s. And he was appointed to the U.S. Court of Appeals in 2003. And then President George W. Bush nominated him as Chief Justice of the United States Supreme Court in 2005. The second of the 9 justices is Clarence Thomas. He's currently the oldest serving justice, longest serving justice. He's been there since 1991, and he got his undergraduate degree from Holy Cross and his law degree from Yale Law School. And he served as a corporate lawyer for Monsanto, which is a fairly controversial corporation, from 1977 to 1979. And he was also a judge on the U.S. Court of Appeals for the District of Columbia Circuit in the 90s. And then in 1991, President Bush Sr. nominated him as a justice of the Supreme Court, and he took his seat in 1991. The third of the 9 justices is Samuel Alito. He was on the U.S. Court of Appeals as well in 1990, and President George W. Bush nominated him in 2006, and he took his seat then. And he also, by the way, went to Harvard University. Sonia Sotomayor is an Associate Justice of the Supreme Court as well. She earned her JD law degree from Yale Law School. You'll notice a pattern here. There's a lot of Harvards and Yales that made their way to the Supreme Court. She was also nominated by President Bill Clinton to the U.S. Court of Appeals for the Second Circuit from 98 to 2009. So you'll also notice that many of these judges served on the U.S. Court of Appeals, again, the second highest court below the Supreme Court. And Barack Obama nominated her as a judge in 2009, and she's been on the court since. The fifth justice is Elena Kagan. She got her JD, again, from Harvard. And she was a University of Chicago Law School professor and later at Harvard. And she was nominated by Obama in 2009, and she took her seat in 2010. The next justice is Neil Gorsuch. He also served on the United States Court of Appeals. And he was nominated by Donald Trump in 2017, and he took a seat. The next justice is Brett Kavanaugh. Brett Kavanaugh went to Yale Law School, and he was nominated by Donald Trump in 2018 and took a seat. And then we have two more justices to go, and the next one is Amy Coney Barrett. She got her law degree from Notre Dame Law School, one of the few that did not have Ivy League background. She was also a law professor for the faculty of Notre Dame. President Donald Trump nominated her in 2020. She took her seat. And she was also a judge on the United States Court of Appeals. And the most recent judge to be nominated was Ketanji Brown Jackson. And she was a U.S. Court of Appeals in 1997 to 1998. And she earned her degree from Harvard University, her law degree. And she took her seat in 2022 under Joe Biden. So we have 9 judges. And currently speaking right now, we have 6 of those 9 judges are Republicans or conservative leaning. And 3 of those were appointed by liberal presidents. So they're more liberal leaning. So definitely the Supreme Court right now is slanting heavily towards the right wing, more conservative. So my question for everybody here is, what has the Supreme Court been up to over the past year or two? Well, they've been involved in some very important matters. They've decided issues on abortion, essentially overturning Roe v. Wade, which was very controversial. And they turned the regulation of abortion back to the individual states. The Supreme Court also controversially ruled that the President of the United States, while in power, is immune from any criminal prosecution for acts related to his official duties. Some critics have pointed out that this may give the President unconstitutional powers, essentially allowing him to evade accountability that is normally expected of our representatives and other government officials. The Supreme Court has also been involved in issuing rulings that scale back or roll back domestic climate change initiatives. This has been very controversial for environmental activists. And the Supreme Court has been involved in matters having to do with rolling back they've been asked to roll back DEI DEI initiatives. The question is DEI programs legal? Should they be seen as constitutional in public places? In other words, do they have the effect of leading to reverse discrimination? The Supreme Court will be ruling on that in the next year. So as you can see, they delve into very controversial territory. So I thank you for your attention today, and I hope this lecture has been helpful for you. So much peace to everybody. Take care.